In Berkeley Community Villages and Pullen, Justice Morgan set out a definition of good faith. He set out that the doctrine was an obligation to observe reasonable commercial standards of fair dealing in accordance with the parties' actions, and also requiring faithfulness to the agreed common purpose. In short, a duty of good faith requires following reasonable standards of commercial dealing and taking into account the reasonable or honest expectations of the parties. Good faith features heavily in other legal jurisdictions, such as Germany or the United States. Paragraph 242 of the German Civil Code sets out an obligation to carry out contracts in good faith. Similarly, in the United States, the Uniform Commercial Code establishes that, for contracts, there is an obligation of good faith in its performance or enforcement. Further jurisdictions such as France or Australia enforce good faith as a principle, but the UK stands out from the crowd as it does not. English law does not adopt a full principle of good faith. In Interphoto, Lord Bingham pointed out that English law had committed itself to no overriding principle of good faith, but has developed piecemeal solutions in response to demonstrated problems of unfairness. English law standing out so much from other jurisdictions is perhaps what prompted Justice Leggett to claim that English law was swimming against the tide. Good faith remains a divisive topic in English law, and it has made some progress over the years. The Consumer Rights Act 2015, at section 62, requires B2C contracts to take good faith into account, stating, "A term is unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer." The question remains, however, as to whether duty of good faith should spread to B2B commercial contracts. Good faith can be enforced as a duty if it is written as an express term in the contract, but many remain opposed to it becoming a duty that courts can imply into a contract without an express term. Yam Seng has been the furthest development of good faith in English law so far. Whilst it does not find a general duty of good faith to exist, it suggests that, depending on context, courts will be able to imply a duty of good faith into a contract. Good faith as a concept came under heavy criticism in the 1992 case of Walford and Miles. Lord Ackner ultimately held that an obligation to negotiate in good faith is unenforceable. Notably, Lord Ackner stated that the concept of a duty to carry on negotiations in good faith is inherently repugnant to the adversarial position of the parties. Each party to the negotiations is entitled to pursue their own self-interest, so long as they avoid making misrepresentations. In short, Lord Ackner argues that contract law is based on the idea of pursuing one's own self-interest, and a potential contracting party should not have to consider the expectations of the other party. Arguably, good faith goes against the principle of freedom of contract. By requiring parties to take into account the legitimate expectations of the other party, it undercuts the idea that parties should be free to engage and disengage in negotiations as they wish. It removes the element of self-regulation which underpins English contract law. Ackner also criticized good faith as creating uncertainty in contracts, stating, "How is a vendor ever to know that he is entitled to withdraw from further negotiations? How is the court to police such an agreement? A duty to negotiate in good faith is unworkable in practice, as it is inherently inconsistent with the position of a negotiating party. It is here that the uncertainty lies." Professor Brownsword also points out that good faith presupposes a set of moral standards against which contractors are to be judged, but it is not clear whose or which morality this is. It would also require courts to delve into the states of mind and morals of the contractors, rather than taking an objective approach. Uncertainty in good faith was also criticized by Michael Bridge in his article, stating that good faith is an imperfect translation of an ethical standard into legal ideology and rules. Good faith is an invitation to judges to abandon the duty of legally reasoned decisions and to produce an unanalytical incantation of personal values. Good faith is arguably unnecessary because, as Lord Bingham pointed out in Interphoto, English law has alternate, piecemeal solutions that take the place of good faith. For example, certain areas of contract law, like the law of duress, assess bad faith. The courts will determine whether a party has acted in good or bad faith based on the facts. For example, in the Universe Sentinel, it was held that dock workers acted in bad faith by striking in order to extort money from their employer. Unfairness, the thing a doctrine of good faith intends to minimize, is also mitigated through doctrines such as frustration or misrepresentation. These areas of law are clear and are not complicated to apply, whereas a doctrine of good faith would perhaps be a more vague method of achieving justice. Finally, a large problem surrounding good faith is that it is heavily reliant upon context. Justice Leggett pointed this out in Yam Seng. The content of the duty to perform a contract in good faith is dependent on context. It depends not on either party's perception of whether a particular conduct is improper, but on whether in the particular context the conduct would be regarded as commercially unacceptable by reasonable and honest people. Context will alter differently between different situations. Arguably, in order to provide proper, nuanced justice, contract law needs to take context heavily into account. Applying good faith irrespective of context would be problematic. Professor Brownsword points out, a general doctrine of good faith would make little sense in those contracting contexts in which the participants regulate their dealings in a way that openly tolerates opportunism. Such contexts would include the commodities markets, which Michael Bridge describes as intrinsically competitive. However, Ewan McKendrick points out that not all contracts are concluded in such a competitive environment, and, where they are not, the law should not necessarily be so hostile to the existence of an obligation to act in good faith. Taking this into account, this then leads me onto the arguments for adopting a duty of good faith. There are several good arguments for adopting a duty of good faith. Chief among them is that good faith could reduce exploitation and would protect the genuine expectations of the parties. If contract law is to protect justice, it is not unreasonable to suggest that measures could be taken in order to protect the honest expectations of those contracting. Lord Stein pointed this out in First Energy and Hungarian International Bank. A theme that runs through our law of contract is that the reasonable expectations of honest men must be protected. Good faith would also likely create a contractual environment of greater trust, meaning parties are more likely to cooperate and negotiate more openly since they are protected from exploitation and opportunism. Lord Stein also has numerous criticisms of the arguments in Walford and Miles against good faith, on the basis that, without it, contract law would not punish a party who negotiated in bad faith but did not make any misrepresentations. He stated, "The Unidroit principles make clear it is obvious that a party is free to negotiate and is not liable for a failure to reach an agreement. On the other hand, where a party negotiates in bad faith, not intending to reach an agreement with the other party, he is liable for losses caused to the other party." That is a line of reasoning not considered in Walford and Miles. It appears problematic that Lord Acton dismissed the concept of good faith out of hand. As Ewan McKendrick put it takes away the party's freedom of contract in that it denies to them the ability to assume, voluntarily, an obligation to negotiate in good faith. This then leads me on to express and implied terms. Despite Walford, parties may write into the contract an express term which provides a duty to negotiate in good faith. However, courts have applied this restrictively, as James Hannart points out. Whilst the courts are willing to give effect to a contractual term which imposes a general duty of good faith on the parties, their approach to construing such clauses has been restrictive. Good faith clauses are unlikely to be construed as imposing a general duty on parties. Hannart outlines several cases which shows this, such as Fujitsu Services and IBM United Kingdom, which had a term requiring parties to act with good industry practice. Hannart pointed out that this was separately defined as the parties seeking in good faith to comply with its contractual obligations. Despite this term, it was held that the way it was written did not support a general duty of good faith. Courts then seem reluctant to apply even express provisions for good faith. It seems then that the clauses intending to provide such an obligation must be written even more clearly by the parties. Justice Leggett in Yam Seng ultimately found that good faith could be implied into commercial contracts, based on the presumed intention of the parties. Leggett explained that it would be hard to envisage any contract which would not reasonably be understood as requiring honesty in its performance. He also pointed out a statement from Lord Bingham in HIH Casualty and Chase Manhattan Bank. Parties entering into a commercial contract would assume the honesty and good faith of the other. Absent such an assumption, they would not deal. Leggett also outlined his view that many of the criticisms of good faith were exaggerated. The duty is based on the parties' presumed intention, that it is open to the parties to modify the scope of the duty by the express terms of their contract, and, in principle at least, to exclude it altogether. What constitutes fair dealing is defined by the contract and by those standards of conduct to which, objectively, the parties must reasonably have assumed compliance without the need to state them. In summary, Leggett's view is that it would be strange to take the position that contractors would not assume honest dealing, since, if that were true, they would not deal in the first place. Additionally, he points out that the scope of good faith is defined by the parties in express terms, not by the courts. To these points, I agree. So, finally, should English law adopt a notion of good faith? It seems that a blanket implementation of good faith would not be ideal. However, neither is dismissing the concept out of hand. It seems unwise for courts to imply a general duty of good faith into contracts when not expressly provided for in the contract. Parties should be free to pursue their own self-interest, and it seems to me that courts implying a duty after the fact flies in the face of this. Furthermore, as contracts are so heavily dependent upon context, a general duty of good faith would not respect this fact. I submit, therefore, that a general duty of good faith should not be implemented. However, again, good faith still should not be dismissed completely. I propose that good faith should be implemented when it is written into the contract as an express term by the parties. This eliminates the issue of courts infringing on freedom of contract and party autonomy. It also means that parties are able to protect themselves from exploitation by agreeing to subject themselves to good faith. Despite the fact that English law has piecemeal solutions to problems of unfairness, such as frustration or duress, adding a notion of good faith, when expressly desired by the parties, can only improve contract law's toolkit in ensuring a just outcome. Furthermore, doctrines like duress already assess the subjective intentions of the parties and whether they acted in good or bad faith. So allowing parties to create an obligation to act in good faith is not much more of a leap than this. However, as discussed, courts have been very stringent in their willingness to apply a general duty of good faith, even when written expressly. To counter this, going forward, parties should draft their good faith clauses extremely carefully in order to ensure the duty is implemented by the courts. Courts should of course remain sensitive to careful wording and context, but should still be willing to apply a duty when provided for in contract. I concur with James Hannart, who in his article said, "The content of a duty to act in good faith is entirely dependent on context, and context will change on a case-by-case basis. However, it is open to parties to either exclude or define that duty, and, by careful drafting, any uncertainty can be minimized." In conclusion, the English hostility towards good faith is misplaced. Parties to a contract should be allowed to define the scope of good faith in express terms, and the courts should be able to enforce that duty. I agree with the British Institute of International and Comparative Law, who stated that courts may wish to adopt a more conciliatory approach to avoid and/or minimize protracted legal disputes without prejudicing or altering parties' legal rights. In my view, my proposal would not prejudice or alter the legal rights of the parties, but it would enable a conciliatory and fair approach towards contracting.